Writing a will is one of the best ways to distribute your assets upon demise. It allows you to name the executors of your estate, the beneficiaries of your estate, and also what each beneficiary will get from your estate. My name is Ayoola Hassan. I'm a senior associate on the firm. In this video, I will be addressing questions that will explain how to claim your inheritance as a beneficiary under a will, with focus on land or landed properties. A will is a legal and testamentary document used by a testator to state how his or her assets should be shared upon demise. It is one of the best ways of transferring legal ownership in real property to a beneficiary upon the demise of a testator. To activate a will, the executors must obtain a grant of probate from the probate registry of the state high court where the testator owns properties. The grant of probate confirms the validity of a will. It also authorizes the executors of the will to manage the estate in trust for the beneficiaries. At this stage, the legal ownership in real properties still resides in the estate. However, it is managed by the executors of the will in trust for the beneficiaries. No. Only the executors named in a will can apply for the grant of probate. However, this can be done by engaging the services of a lawyer who is experienced in probate matters. A beneficiary can only act if the court appoints him or her to act as an administrator when the executors named in the will refuses or is unavailable to act. To transfer legal ownership in any land or landed properties devised into a beneficiary, the executors of the estate must execute a deed of assent in favor of the beneficiary. A deed of assent is a legal document that transfers legal ownership in real properties to a beneficiary. Upon the execution of a deed of assent, the legal ownership in a real property ceases to reside in the estate. To crown the legality of transfer of legal ownership in land or landed property to the beneficiary must register the deed of assent at the land registry where the property devised unto him or her is located. During the registration process, the governor's consent is obtained. Upon registration, the beneficiary can deal with the property the way he or she deems fit, including sell, mortgage, lease, or even gift. If the executors of a will refuse or are unavailable to act for reasons of death or ill health, the beneficiaries of the will can approach the High Court for the removal or replacement of the executors. If the High Court is satisfied with the application, it can appoint the next available person as the executor, or if none is available, the court can appoint administrator with will annexed. The court order appointing the administrator with will annexed will thereafter be used to obtain letters of administration with will annexed from the probate registry of the High Court. In conclusion, being a named beneficiary under a will does not automatically transfer legal ownership in real property to you. As explained in this video, there are steps that must be taken before legal ownership or interest in real property can be transferred to you as a beneficiary, and I hope you find this video helpful.